Your Lordship, I beg to mention item number 9, Your Lordship.
You have responded?
Respondent. And for respondents 1 to 5, Your Lordship, for the state. No objection, Your Lordship.
On prayer made by the petitioner.
Your Lordship, I kindly pray 4 weeks, Lordship.
This is matter of 4 weeks.
Highly obliged, Lordship.
Please, Your Lordship. Lordship, I beg to make a mention on item number 6, Your Lordship.
No objection, Your Lordship.
2017 matter.
Yes, Your Lordship, actually, counsel who's handling this matter, Your Lordship, she's not keeping well, Your Lordship.
I'm appearing for respondent 4 to 6.
On prayer made by the
I'm appearing for respondent number 1, 2, and 3.
prayer made by the petitioner, not objected to by respondents. This is matter of 2 weeks.
Similar prayer for item 10, Your Lordship.
Item
10. State respondent is there, Your Lordship.
who's appearing?
State respondent, Your Lordship.
On prayer made by the petitioner. This is matter to 3 weeks.
Right, Your Lordship.
Please, Your Lordship, I beg to mention item number 8. I pray for 3 weeks' time, Your Lordship. I've informed the other party.
Item 8.
Yes, sir.
No.
You are for?
Respondent number 5, Your Lordship.
Petitioner is ML non pure.
No objection, Lordship.
How long is it?
3 weeks' time, Your Lordship.
You are a private respondent.
Yes, Your Lordship.
This is basically, between the petitioner and the state.
No, the dispute is between the petitioner and the managing committee of the school, Your Lordship, because the petitioner was
You are the managing
dismissed.
committee.
Yes, Your
The
Lordship.
managing committee had dismissed the writ petitioner. So against that order of dismissal, Your Lordship, there was a stay, Your Lordship. There was a stay. But the only thing is that the school is not running. It has been under lock and key. At the present situation, I don't know, but those when the writ petition was found out, that was the situation.
Yes, Your Lordship. Even till date, it is under lock and key.
How many teachers do you have in the school?
2 teachers, I think it's a 2-teacher school.
Teacher. How many students?
Lordship, because according to the affidavit filed by them, is that the petitioner is a very bad teacher.
No, I'm talking about the students now.
A student it must be below 20 or
Then
maybe
where
10
are
to
they
15.
now? Where are they?
Somewhere in
No,
south.
are the students coming? They are not coming to school
No,
anymore.
Your Lordship.
No, they are not coming to
So
school.
they must have transferred or shifted to some other schools.
No, the only
Yes,
problem
Your
is that we are giving the salary. So if Lordship, this matter can be sorted out, Lordship.
Your Lordship, in that case, I would like to pray for 2 weeks' time, Your Lordship. It is be better.
Yes, finish it off.
If
Because
they want to take penal action or disciplinary action against the petitioner, they have to do as per the procedure.
Yes, but Your Lordship, our only problem right now is if the teacher is in the school, none of the students are willing to.
but that is, it doesn't fit any provision or norms for that matter. Disciplinary action, as Mr. Shulai said, can be taken. So either you can caution, or you can counsel, or you can reprimand the.
Yes, Your Lordship.
teacher,
Because
but-
we have given her chance to
In this
reply.
case, Your Lordship, in this case is no work, yes pay. Lordship,
We cannot allow this. On premier by the respondent,
Lordship, private respondent, Lordship.
respondent managing committee.
5, Lordship.
This is matter to 2 weeks. So 2 weeks.
2 weeks. Apply, Your Lordship.
Oblige, Your Lordship.
Lordship, I beg to mention item number 5. pray for a week's time, my lord.
No objection, Your Lordship.
On pre-made by the petitioner, this is matter up to 1 week.
May I please, Your Lordship, I beg to mention item number 11 and 12, Your Lordship. Let this matter be taken after 2 weeks because we need to go through some more time, Your Lordship, the record.
They are connected matters.
Same.
Yeah, for respondent on pre-made by the petitioner, this is matter up to 3 weeks.
Next.
Lordship, may I beg mention of item number 13? My lord will take it up next week's,
What is this matter about?
This matter regarding that I have challenged the power of the City Council of entering the maintenance application when the parties, though both the party are tribal, but they are
Different
residing
districts.
in 2 different districts, my lord.
That is well settled, I think. There's nothing to it. Supreme Court judgment is there. How long?
A week's time, my lord.
On pre-made by the petitioner, this is matter up to 1 week.
Much obliged.
Highly obliged, my lord.
Supplementary cost list, item number 1.
Every Your Lordship.
Yes.
Lordship, we filed this application under section 430 of the CRPC, Lordship, for the release of the accused person on bail. My lord, the brief facts of the case is that my accused person, my lord, he's a driver. On that fateful day, these 3 accused person had booked my vehicle to go to Nongpol, Lordship. So accordingly, my lord, I have gone along with these 3 accused persons. So while, my lord, we are coming back, so in between, my lord, what happened? May I just take your lordship to the FIR? It's at page 10, lordship. Next one, page 10, lordship.
Yes.
May I read, lordship? With reference to the subject cited above, I am to inform you that on 26/3/2023 at about 4:30 p.m. received telephonic information from reliable source that one person suspected to be carrying contrabands was coming from Guwahati ISBT site and proceeding towards Shillong site. Accordingly, received of the information, self along with SI B Dingdo, H/C B Bordoloy, B Rana, R Kurba and BNC personnel started conducting Naka checking at NH6 road near Banihat OP. However, on arrival of the taxi B registered number ML05M7648 was detained near OP on the driven by Sri Vijay Thapa. So I am the driver, lordship. Son of late so and so. Further on questioning one of the occupant, namely Sri Dilip Molong. Malme, kindly take note of it. Son of Sri so and so, who occupied the front passenger seat, and Sri so and so of so and so East Castle Shillong sit on the rear passenger seat. Further on questioning Dilip Molong, who revealed, Malme, kindly take note of it, Sri Dilip Molong, who was sitting in the front seat, he revealed that they are carrying illegal contrabands. Accordingly, the matter was informed to the Honorable SP Sri so-and-so. Later, Honorable Superintendent of Police so-and-so, on his arrival, authorization was given for body search. A notice under section so-and-so was given to the above said person, and they agreed to be searched in presence of Geo. Accordingly, body search was conducted on the spot, presence of independent witnesses, and found one mobile phone, so-and-so in black color, from Dilip Molong, and one Sri so-and-so, one Sri Bansngan Cooper Kongdup, found one mobile phone golden in color, and Sri Bijay Thapa found one mobile phone, Redmi, green in color, was found. However, on further checking, the detained local taxi bearing registration number 7648 found two numbers of carton boxes where the driver under the driver's seat and under front passenger seat. Further, two carton boxes were taken out and opened carton boxes and found 14 soap boxes which contained orange and whitish color substance packed in a transparent plastic bags. The weigh and measurement of the contraband was conducted with the help of electrical weighing machine. In course of weighing, the weight of contraband were packed in one number transparent polythene bag, in which one number transparent polythene bag was found weighing 9.63 grams, and the net weight of contraband is 140.37 grams. Later, preliminary test was conducted at the spot in presence of available witnesses using the drug testing kit. The result indicated positive for heroin. Accordingly, the contraband was packed and sealed at the PO. Then were seized accordingly in presence of the witnesses, and accused persons were taken into custody. So, my lord, pursuant to this FIR, a case was registered under section 21B 25/29, lordship. Now, may I take lordship to section 37 of the NDPS Act. May I first read the provision of 21B, lordship?
Is it
21B of the NDPS Act, lordship.
intermediate or
Intermediate, lordship. Intermediate.
So 37 will not apply.
Not apply, lordship. So, my lord, the rigors of section 37 in my case will not apply, lordship. So, this aspect was brought to the notice of the learned special judge, my lord, but this has not been considered. Otherwise, also, lordship, my lord, in recent judgments has held that, my lord, the FSL report, my lord, was not submitted in this instant case, lordship. That aspect also was apprised. In fact, this the order passed by the Honorable Court also was placed before the learned special judge, lordship.
That person was that was clarified in a later judgment.
Lordship. So here, lordship,
Was the issue of the supplementary charge sheet
lordship,
on account of the FSL report not being submitted in time
lordship.
is under consideration by a larger bench of the Supreme Court.
But here,
That issue will remain.
but here, lordship, if I may humbly submit, the rigors of, as rightly pointed by this Honorable Court, by this my lord, that rigors of 37 will not apply. So, my lord, 439, under 439, I may take my lord to a few judgments.
Let us, where is charge sheet has been filed?
Yes, lordship, charge sheet has been filed. I'll point out,
Where is
lordship.
Where is the charge sheet?
We have annexed, lordship. It's at Annex 3, lordship. It's at page 12, lordship. Page 12, lordship, Annex 3.
Yes, Mr. Shulai. You tell me, what is the nexus between this accused, the taxi driver, and those
Lordship,
two
it
others?
appears, Your Lordship, they are in. It appears from the charge sheet, Your Lordship, that they are aware, Your Lordship. Three of them, they are aware, Your Lordship, of all this.
First, you have to link their relationship. Apparently,
Lordship, kindly
this
see.
is a public transport.
Lordship, kindly see. He is a driver, and the thing was kept in his. It was kept in his. It was kept in below his seat, Your Lordship. So, Your Lordship, kindly see the mental state of mind of a person. If a good person, he could have asked, Your Lordship, what is that? Why should I keep that thing in below under my seat? Can you see, Your Lordship? So they are in no, Your Lordship. They are in no, Your Lordship. Three of them, Lordship, they are in no. Lordship, if
You have to get more specific evidence than that as to what is the relationship, whether there are some communication between them.
Lordship,
CDR, what does CDR evidence says? All those things have to be there.
Lordship, kindly see in this case, Your Lordship. If Lordship is kindly see at page 21. Page 21. And kindly come to page 23, Your Lordship.
Page 21 or 23?
First, you come to page 23, Your Lordship. This is the accused, Your Lordship, statement. Lordship, in this, I would like to submit, Your Lordship. Your Lordship, accused, they are not supposed to have the statement, Your Lordship. Can you see, Your Lordship?
Oh, this is the
The accused, Your Lordship. They are not supposed to obtain the statement, Your Lordship. As per 207 of the CRPC, they are not supposed to have the statement, Your Lordship.
This was given to them by the
Charge sheet, charge sheet is filed. In charge sheet, we are entitled.
What I would like to submit, Your Lordship.
charges you are entitled to statement
No,
under
Your Lordship.
161?
No, Your Lordship. Can you have 207 CRPC, Your Lordship? This is very wrong, Your Lordship. The trial court, Your Lordship, in giving statement of the accused while giving copies under 207 is wrong, Your Lordship. Lordship, kindly come.
So then you have
For
to.
this, we cannot be held liable, Lordship.
If the IO is giving it to them, what can
No. This is supplied by the court, Your Lordship, from the most probably by the court master.
By the IO?
Lordship, because this the case diary is submitted to the court, Your Lordship. The case diary is submitted to the court.
Yes, and from there the copies will be made.
Will be made by most probably by the by the staff, Your Lordship. Everything they will keep.
By the staff of
May kindly come to page 20.
Lordship,
List of documents are here, and in terms of this, it has been provided to us.
Lordship, kindly see 207.
For that, Mr. Shulai, you take it up with the trial court.
Lordship, yes. Lordship, kindly see 3.3. The statement recorded under section 3 of section 161 of all persons whom the prosecution proposed to examine as its witness, excluding therefrom any part in regard to which a request for such exclusion has been made by the police officer under section so and so. So they are not supposed to have this copy, Your Lordship. I'm just bringing to Lordship notice.
That's why you take it up with the. See, if there's some defect in the system, or the court or the officers or the staff, whoever is in charge, has through inadvertence done it, that has to be corrected.
Because I'm bringing this defect in the notice of Your Lordship, so that this can be corrected, Your Lordship. This kind of mistake can be corrected, Your Lordship. Through the.
Yes. Heard Mr. Espanti, learned counsel for the petitioner, who has preferred this application under section 439 with a prayer for grant of bail on behalf of the accused BJ Thapa. The legal counsel for the petitioner has submitted that the accused BJ Thapa is a taxi driver and on 26/3/2023 he was ferrying two passengers with him through the Guwahati-Shillong road. However, on reaching Tornihat outpost, police outpost, the vehicle was intercepted by the police, by police personnel who, upon searching the same, has recovered alleged contraband substances weighing about suspected to be heroin, weighing about 140.37 grams. Accordingly, the said accused person, along with the two occupants of the said vehicle, were detained by the police for offences under the NDPS Act, particularly under section 21 under bracket B 25/29 of the said Act. In Nongpo PS case number 31 under bracket 3 of 2023. On investigation being conducted, the investigating officer had filed the charge sheet with the findings that the prima facie case is well made out against the said accused person BJ Thapa and two other co-accused person. I think the stage is at consideration of charges. What is the stage?
No,
of
Lordship. Supply of charge sheet, Lordship. Copies.
The stage is at the stage of the case is for supply of copies to the accused persons. The General Counsel has further submitted that an application for grant of bail has been moved before the trial court on two occasions, which was rejected, hence this application. The General Counsel has submitted that the accused person in question is innocent and has no connection with the alleged offence, inasmuch as he is just a driver and has been using the vehicle for his day-to-day living, and as such has no knowledge of what the passengers carry with them in the vehicle. It is therefore prayed that this petition may be allowed and the bail may be granted with any condition to be imposed by this court. Per contra, Mr. N.D. Shulai, learned AAG, has submitted that the complicity of the accused Vijay Thapa in the case is very much apparent, inasmuch as the said alleged contraband substance was found hidden below the driver's seat, and should we call it under or under
Your
the
Lordship.
driver's
If
seat?
Lordship then kindly have page 23 his statement, Your Lordship.
Let me go to it, which could not have been done so without his knowledge. It is also submitted that the accused person is very well known to the other co-accused person, and as such there is a nexus therein. Accordingly, it is prayed that this petition is devoid of merit and the same be dismissed. This court has given due consideration to the submission made and has gone through the petition and the annexures thereto, including copies, including the charge sheet which has been annexed herein. Needless to say, the evidence in this case has not commenced. The charge sheet has been filed, and according to the IO, there is strong evidence, rather prima facie evidence, that the accused is involved in the said offence. In fact, on perusal of the statement made by the accused under section 161, he has clearly stated that the two co-accused are his friends and are well known to him. Though in a criminal proceedings, the accused, an accused person is considered to be innocent until proven guilty. However, when there is a strong prima facie evidence against such accused, and considering the gravity and nature of the offence involved, this court would be reluctant to be lenient in such a situation. Accordingly, on merit, there appears to be no evidence or factor which would go in favor of the said accused person at this point of time.
If my lord allow me to just permit the statement which my lord senior has referred 21. This is the co-accused lordship. This is the co-accused lordship. Here, my lord, he clearly stated.
Yes, that you see, like I said, it's a matter of evidence. It may not be admissible in evidence.
For the purpose of bail, Your Lordship, a statement under 161 is relevant, Your Lordship.
So it is a 116 lordship. Here, my lord, I'll satisfy this honorable court. There is no evidence against me, my lord, for this at this time. For my lord,
We'll see later, Mr. Pati. These drugs matter.
But my lord, on the similar circumstances, even honorable Supreme Court has, my lord, granted bail. I'll place that on record. My lord, may kindly hear me, my lord.
Then you go to the Supreme Court, Mr. Pati.
I'm just making a prayer, my lord, may kindly just.
In view of the observation made above, this petition is devoid of merit. The same is hereby dismissed.
In fact, Lordship,
if my lord could have at least allow me a chance to apprise certain facts, because there are statements, my lord, which says that
the court has passed the order. It's up to you. If you wish to appeal, go and appeal.
Your Lordship, the state is being bombarded by drugs, Your Lordship.
Not that, that's not the point. You see, everything has to be on the peculiar facts and circumstances of
And
every
every
case.
day, Your Lordship, we are
Excuse me.
catching people, Your Lordship. Highly obliged, Your
Thank you.
Lordship.
Item number 2.
Lordship, we have forwarded the rejoinder affidavit to the concerned deponent. We are still waiting for the signatures. It's ready almost. It's just 10 days time, Lordship.
Mr. M.L. Longpure, counsel for the petitioner, has submitted that the rejoinder affidavit, though that the rejoinder affidavit could not be filed today, as the same has been sent for vetting by the to be vetted to, has to be sent to the petitioner's office for necessary confirmation. And as such, it is prayed that said affidavit in rejoinder affidavit may be allowed to be applied, to be allowed to be filed on the next date fixed. 1 week.
10 days. 10 days time. 2 weeks.
On premier, the same is allowed. List is made after 2 weeks.
2 weeks.
Item number 2.
Yes, what is this, Madam?
Your Honor, last occasion I have mentioned regarding the case, Your Honor, Lordship, that we have already given the service copy to the respondent. So my learned counsel has said that they have to appear in person. For that, he prayed for 2 weeks time.
Who? Appear? Who? Who's appear?
I'm appearing for the state, my lord.
Your Honor, last occasion, your Lordship has said that let the other party, other respondent appear.
Yes, who's the other respondent? Who are the other respondent?
Srimati Momina Baby, who has been arrayed as respondent number 2. Maybe they have taken steps and they have not entered appearance, my lord.
Respondent number 2.
Affidavit of
No,
service.
has he received notice?
Yes, Lordship, she has received the
Have you filed an
notice.
affidavit of service?
Lordship, yes, we have already filed.
What is this case about?
Lordship, this is the FIR filed by the respondent number 2. Which, Lordship, I have mentioned the main effect of the case in the petition in para number 9. Lordship, this is the FIR filed by respondent number 2. The main cause is that petitioner 1 who have filed an RTI application against respondent son-in-law, which I have mentioned earlier also. And regarding this, they have asserted the respondent number 2 son-in-law, who is the secretary of VEC, have assaulted the petitioner number 1, 2 and 3 in the marketplace, whereas petitioner number 2 and 3 is the brother of petitioner number 1. and petitioner number 4 has also been assaulted, and petitioner FIR was filed against them, alleging that petitioner number 4 and his son has wrongfully restrained respondent number 2 son-in-law. Whereas the investigation, when the police take up the investigation, there was no such thing filed against the petitioner number 4 son.
The petitioners here?
No, Lordship, here the petitioner is the mother. Petitioner number 4 is the mother. When they file FIR,
There are, how many petitioners are there?
petitioner, there are
You
4
have made,
petitioners.
there are four petitioners.
Yes, Lordship.
So there are 4 petitioners.
Lordship.
So it would mean that you have come with a prayer in their favor, in whatever manner. Now you're saying that as far as petitioner number, who has, they have been discharged, who?
Your Honor, the son of Begum Lerer Hawk.
Who? He is here. Is he right here?
The
What's his name?
the lawyer, Lordship.
No, the petitioner, the accused who was discharged in due
Lordship,
course.
Yes, Lordship.
You said he was discharged in due course.
Lordship, during investigation, there there was no evidence found against both the son.
So charge sheet has been filed.
No, Lordship.
Yes, my lord, charge sheet has been filed, my
Charge
lord.
sheet has been filed, but as there was no evidence found against the son.
Yes.
In FIR, their name was reflected.
But for these accused persons, accused number, these 4 accused persons, the charge sheet has been filed, my lord.
Okay, so that is,
Yes.
that is what is required. Now yes.
So what I am submitting, my lord, since a charge sheet has already been filed, my lord, so it is not prudent, my lord, to that they are allowed to go under 482, my lord. So let them face the trial and let them argue before charge, my lord, whatever be the case, my lord, because the charge sheet has already been filed. Police were asked to look into. There was it seems like the matter started from some VEC management and some funds and RTI applications, and out of that scuffle certain FIRs were filed. 2 cases were registered, my lord, and both of them police has taken cognizance, my lord.
Lordship, Lordship, in this incident, we have filed the first FIR. Lordship, here the main fact is that when I have mentioned in my parent 9, when this petitioner number 4, when she was outside her house, she met the son-in-law.
You're going to the facts. You see, what happened is, you have filed an FIR.
Lordship, yes.
And that FIR has been taken to taken to account. Case has been registered. So investigation has started or is on the way. The charges has been filed in that case.
Yes, Lordship.
Okay.
And as far as my information,
so as far as your FIR is concerned, so it's a different proceeding.
It's a different proceeding.
Yes.
Now, perhaps a counter FIR has been filed or a separate FIR has been filed, for which investigation has also been conducted and completed. On completion of the investigation, the IO has found that there are materials against you for which you have to stand trial. To that extent, we can understand that there is a there's a progress in the matter. If you have come before this court under 482, firstly you must show that the proceeding before the trial court or even with the investigator, of course now charges has been in violation of some order of the according to the provision of the court, or more often than not that for ends of justice there was a gross injustice against you. But even then, that would be a very vague submission. You have to be specific. And in any case, since a criminal prosecution has been launched, the High Court cannot at any point of time scuttle the system. It has to be allowed to go. If at all you are found innocent, evidence will speak for themselves. But as it is now, I don't think there's any material for you to come before this court. Except more often than not, in an application for under 482, if parties have come to a compromise,
Yes.
have settled the matter, there are relevant authorities to that, which would assist this court to come to your rescue for that matter.
Lordship, here we don't have any malafide intention. It's clearly shown in my.
True, but you still have to prove yourself.
And Lordship, as I'm
Even you also have a chance, number one, to argue before charge, and number two, if at all that is not allowed, you still have a chance during the trial to place your evidence or place your side of the story under section 313 and other provision. Finally, if worse comes to worse, you are convicted, you still have the provision for appeal. So we'll have to leave it at that. That is a system. But coming before this court at this point of time, I don't think would be proper. Excuse me. Heard Ms. Learned counsel for the petitioners who have submitted that an incident had occurred on have a seat, on 6/7/2022 involving the petitioner number 4, when she heard unusual noise emitting from a marketplace which is nearby. And on proceeding towards the place of occurrence, she witnessed a scene where there was a scuffle between the son-in-law of the respondent. Is it respondent number 1 or 2? Respondent number 2 and the petitioner number 4, or is it petitioner? The fight was between the son-in-law of the respondent 2 and petitioner number 2 and 3.
Yes,
1, 2 and 3.
And 4 also.
4, so she was involved later.
Lordship, in this petitioner number 4, she was there. She was near her house when the respondent son-in-law was coming towards her house, and he told her that I'll not spare you, and he assaulted her also at that point of time. She has not involved in the fight, but respondent number 2 son-in-law has assaulted her.
Change now again. According to the learned counsel for the petitioner, the genesis of the matter leading to the criminal case being filed before the court is that on 6/7/2022 at about 10 a.m. the son-in-law of the respondent number 2 herein accosted the petitioner number 4 and hurled abuses at her and also tried to assault her. In the meantime, the petitioner number 1, 2 and 3 came to the scene in an attempt to protect the petitioner number 4. After the incident, they came to know that the where is the FIR?
Page 17, my lord.
That the respondent number 2 had lodged an FIR against them. Accusing that the petitioners herein have assaulted and threatened her son-in-law. On receipt of such complaint, the police had accordingly police has registered the FIR, and accordingly, where is the case number?
Accordingly, case West Garo Hills PS Haldiganj case number 77 of 2022
under section
341, 506 and 34.
341, 506 and 34 IPC was registered. An investigation was launched. Next, the investigating officer in due course has filed his report and charge sheet, wherein he has opined that where is the charge sheet?
It's number 20, Lordship.
Yes.
Page number 26, my lord. Middle. I therefore submit charge sheet under section 341, 506, 34 IPC against the accused person A1 to A4.
Go to last line. A case is well made out against the petitioners, against the accused person oblique petitioners herein under section 341 oblique 506 oblique 34 IPC, and they are accordingly sent up to stand trial before the competent court of jurisdiction. What is the stage of the case?
Lordship, it is fixed for copies and appearance of the accused.
Copies.
Lordship, my humble request is that the petitioner number 4 is an old lady. She's 68 years old. If she can be exempt from the appearance in the court.
Yeah, that you can always apply for that. Surely they will give you. The stage of the case is at the is fixed for supply of copies to the accused person therein, who are the petitioners herein.
My lord can only give expeditious trial to the petitioners.
These are
That will
sections.
serve the purpose. If they are innocent, they will come out
offense are very
early.
offense are not serious offense.
Yes, my lord.
Okay.
Expeditious trial will
In fact, they could
serve
have
the purpose.
In fact, they could have. They should
Petitioner only,
But they should have. Somebody should have mediate and.
Yes, my lord.
Find a,
that could have a solution, and
but you can always compromise.
at any point of time they can again come back. There is no bar as such.
You can always do that.
If the circumstance changes.
Yeah, if you try to settle the matter with the complainant and file a joint compromise petition or whatever, or
Lordship, they being an influential person, Lordship, they I don't hope that there is any light of
let the trial court
And Lordship, this is just to harass us only,
true.
Lordship.
But then what can we do? You have to prove your case. You have filed your counter affidavit, counter FIR. So let us see what will happen. If at all the police fail to take action on that, then you file an application before this court or before a competent court. Mr. S. N. Gupta, the additional PP has submitted that there is no has submitted that the procedure as far as the said case is concerned has been conducted in accordance with the provisions of law, and the trial has proceeded accordingly. The petitioners has to prove their innocence in due course, and as such, to scuttle the proceeding at this point of time may not be for ends of justice and would only frustrate due administration of criminal justice. It is therefore prayed that this petition may be dismissed and the petitioner be directed to joint trial. On consideration of the submission made and on perusal of the petition in hand, this court has observed that the investigation into the case has proceeded in right earnest. Materials have been collected against the petitioner, which has to be proved in course of trial, and as such, it would not be proper for this court at this point of time to short circuit the proceedings and to allow this petition, which would in effect be considered a dismissal in their favor without any evidence having been adduced in the case. Be that as it may, there is no merit as far as the prayer made in this petition is concerned. The petition is accordingly dismissed. Petition disposed of, no cause.
Item number 4.
Lordship, I filed my affidavit, Lordship. Additional affidavit.
You file your additional affidavit?
I filed it.
You have received copies?
Already concluded the hearing, my lord, and just my learned senior friend wanted to bring the additional affidavit, which was they said that was filed but was not placed in the case record. So,
but have you received?
Yes, ma'am.
No copies of the
No,
earlier.
No, ma'am.
Then.
But we are not aggrieved by those things because our case, what we have already stated. Managing committee, they have stated their case, and it is the petitioner who is trying all means to.
So in that case, there is no objection to the filing of the.
No, Lordship. In fact, the affidavit which my learned friend has filed, we have already answered when we received the copy. Now in the new form, I find that there is some changes.
So would
Copy
you like?
was served. He said it is not available.
Would you like to?
No, I
file
don't have. We have already replied, Lordship. We have already replied the available, and any other things orally I will try to submit, Lordship. Reference to my
So
earlier.
we'll give it this way. He has filed the additional affidavit.
Yes.
You don't want to. None of the respondent would like to respond to it or file a rejoinder. So the matter ends there. So, Mr. Devnath, you can address the court accordingly.
My lord, it's not that we don't have objection, but it is too late in the day to get an objection from our concerned clients, my lord, because already the counter affidavit, rejoinder affidavit, everything has been done. And now at this stage, if we ask our officials again go back in time and give a fresh response, it's just like filing a new writ petition, my lord.
Exactly.
So that is what
Lordship.
I am saying. What we can do is that without considering the fact that we don't have objection, my lord can take into account that is.
You see, whatever the case may be,
But if it is reflected that we don't have objections,
no, what you can do
then
is,
it will
but
reflect bad
since
on
an
us.
affidavit has been filed, it is due process or the normal course where you have to file a rejoinder.
But it has not come in the due process.
If you don't wish to, but it has been
Here it is a
it
very
has been
rare
taken
case.
on it has been taken on board
Yes.
on the strength
For the
of
hands of justice,
on
for
the
the
strength
hands of justice.
on the strength of the order of this court.
Yes, ma'am.
So if you don't wish, if you wish not to file any rejoinder or oppose it,
We'll proceed with the hearing.
then we'll proceed with
We'll
the hearing.
proceed with the final
And in the meantime,
Yes,
you can
ma'am.
always
Without
advance.
without indicating
Yes,
that we
you
have
can
moved on.
you can always advance your argument.
Lordship, can I make a submission that in my case from the respondent schools, we have earlier in 2019 filed our written argument, synopsis. Now, when my friend has taken some development saying, I think Honorable Court will permit me to file a fresh one, the consolidated by earlier one in the recent development which is taken, I will file it, Lordship, if I am allowed so kindly.
That we can do.
Yes.
In the meantime, this court has heard the oral argument of
Yes,
parties.
I have almost completed
Yes.
on that day, but not yet concluded. But a major part I have already
Mr.
completed.
Devnath, you have finished your part.
This little bit.
It means the Dinombo he likes to praise.
He's going back.
No, Your Lordship, already I have
Only
given
you see now.
Your
what-
Lordship, already I have
if
filed.
you have already started with your
So, Your Lordship, already I have given my this synopsis written one, and I'll be based on it. I'll not be coming anything new matters. Only
That's
just
it, my lord. We have already given our written
So
argument.
we'll
as
hear
well.
the matter then.
We can base on that only.
So we'll hear the matter when next week.
After 2 weeks, my lord.
Mr. R. Devnath, and counsel for the petitioner, has submitted that the additional affidavit sought to be filed by the petitioner has been accordingly filed. The learned counsel for the respondents, in the meantime, have submitted that this matter may be that the hearing of this matter may be finally concluded on the next date fixed. So 2 weeks. 2 weeks.
Yes, sir.
So be prepared. You complete your argument and let them reply whatever they are. Then after that we'll see. If an argument is required to be filed, then
I'll
you
be
can file.
stand on it. You will say already I have given the written.
Whatever.
Just to
You
explain.
revise it, orally submit.
Yeah, because whatever you have submitted, see now, I don't know when was the last hearing. This court must have forgotten. You have to refresh the court. On premeditated party, release this matter after 2 weeks.
Item number 7.
Excuse me. Yes, Mr. Chanda, what is required here?
This is regarding my lord. Final hearing. Denial of opportunity of limited departmental promotion, which was introduced by the Minister of Home Affairs.
So, this matter has not been heard.
Not heard.
Should we continue the hearing today or up to you?
There's no such urgency.
If you want to take it up, we'll take it up in the post-lunch session.
I don't know, one aspect only, that MHA did not file any affidavit in opposition. The respondent, one officer of legal side of Assam Rifle, he has filed, but I think, my lord, in the facts and circumstances of this case, MH Secretary, respondent number 1, should file an affidavit in opposition.
Is he, who's are you representing?
There, my lord, one A.S. Sidhu, resident of Lightcore, Shillong, his designation also not given in the affidavit in opposition and not mentioned for whom he is filing. 1, 2, 3, there are
only 2 respondents here.
There are two respondents. So, the Secretary, Government of India, Ministry of Home Affairs, this circular was issued by the Ministry of Home Affairs, which I am relying upon. Therefore, it is necessary, my lord, that Secretary, Ministry of Home Affairs should file an affidavit.
But why at this point of time?
That's what, my lord, after 5 years now. But my lord,
whatever the case, you see, if what Mr. Chanda is saying, if you have failed, you are required to file an affidavit. You have not filed, so inference will be drawn.
The affidavit is filed on behalf of all the respondents, my lord.
All respondents.
All the respondents. We will rely on that.
My lord, my humble submission, they are not entitled to file for Ministry of Home Affairs under the business of rule.
Who?
There. Until a authorization is specifically comes. Until an authorization, because this circular itself is issued by the Ministry of Home Affairs. They have partly adopted the circular. Limited competitive departmental examination to the grade of assistant commandant, they are conducting. But limited departmental examination in respect to the for promotion to the grade of Naib Subedar, that is sub-inspector, they are not conducting, and their plea, the sole plea is that it was not addressed to us. This letter, all the CPOs, it was introduced, given copies, but not given to us. That is the stand in the affidavit in opposition. If that is the stand,
not to the personnel of the Assam Rifles,
or not to the personnel. If that is the stand, how could you conduct the assistant under the same circular? 17% promotion, limited departmental promotion you are conducting under the for the assistant commandant under the same circular, Annexure 3. Therefore, clarity, because it is the Ministry of Home Affairs. Because your Lordship, Assam Rifle also under the Ministry of Home Affairs. All the CPOs are under the Ministry of Home Affairs. All the CPOs, even I have enclosed their limited departmental examination conducted by the Assam Rifle in respect of assistant commandant. I have enclosed those orders.
So if you have to clarify on that, then you have to seek instruction.
Let my friend take instruction on that.
I don't know what.
No instruction is required, my lord.
No.
My lord, Ministry of Home Affairs does not file affidavit in each and every case, my lord. In all the cases where Assam Rifle is the administrative department, my lord, they file. Where BSF they file, where CRPF they file, my lord. It is not necessary for the ministry to file affidavit in each and every case, my lord.
They said
well, my lord, what is submitted by Mr. Chanda in my humble submission is not correct, my lord. We have not said that this has not been addressed to us. That's not the ground. We are saying that we are not CAPF. That is our ground, my lord. And this circular is applicable only to Central Armed Police Force.
What is the difference between CAPF and CPO?
Because Assam Rifle has been excluded from the purview of CAPF. Because, my lord,
is there a distinction?
Because Assam Rifle is headed by a Lieutenant General, my lord, not by IPS officer, my lord. And the command structure is of Colonel, the army officers are. Because our Assam Rifle is slightly unique from the other paramilitary forces, my lord. Because other BSF, CRPF, my lord, they are manned by IPS and police, my lord. Assam Rifle is under the operational control of army, my lord, because it has to deal directly with the neighboring country.
So you see.
So we are saying that our command structure is totally different.
So there are about some of the terms are overlapping. There is the CPO.
Yes, my lord.
Central Police Organization. And there is the CPF,
CAPF again.
And CAPF. So what is what?
My lord, we have said that also in affidavit, my lord, that Assam Rifle has been excluded, my lord,
From
the definition of CAPF.
CAPF. So it falls under CPMF.
My lord, it is a different category altogether, my lord. It doesn't fall anywhere, my lord.
I think there are many authorities to that.
I have brought a judgment where this clarification
So if you,
is given.
Anyway, if you feel that you don't need to file any, so we'll proceed with the hearing.
Well, only that of the it may come on some other day. Only that I pray that that my lord, that may be recorded, that Ministry of Home Affairs.
So let's see, you fight your own case, Mr. Chanda, and if they choose not to respond to that, then you have the edge.
Yes.
My lord, I have enclosed in the one of the set of judgment. I'll address it on the next day.
That is why.
I'll address it on the next day. Here in the Abhay Kumar case of this honorable court, the Ministry of Home Affairs letter was quoted in the judgment, where it said BSF and others all are in the same. Assam Rifle is also included there. That was noted in the
But
judgment.
I recall, you see, I may not remember correctly. I recall there are some
Yes, my lord.
decision of the Supreme Court which says that Assam Rifle is CAPF.
I don't know. At this today, now
In
at
fact,
this stage,
with regard to those cases
my friend is saying like this.
What case? Those cases which we have
Pay
done.
parity will come.
Pay parity
will come at a different level, my lord, because they are also, because we have Havaldar, my lord. In BSF, they have sub-inspector, my lord. So, but entry criteria and other things are same. So this honorable court held that they will be entitled to same pay because they are all under Ministry of Home Affairs. But this is affecting even the operational structure of the hierarchy, my lord. Because here what happens, my lord, are because the colonels from army and major and captain, they come and command the structure of Assam Rifles, my lord. So we take them on deputation, my lord. If we bring in this departmental 17%, so that will upset the entire.
You have already introduced of the same memorandum, already introduced, and they're doing it. What my friend is saying, I am strange.
So you will cite your instances then. When do we have it?
My lord, getting beyond 12th, my lord. 12th, I have got some cases here.
This 12th?
This coming 12th.
Today is 6th.
Or otherwise on 24th. On 24th.
24th, my lord. 12th, 12th.
24th.
Fine. On pray made by the parties. This is matter on 24th. 24th.